reduced to wearing headphones. That's where we're at, ladies and gentlemen. Reduced to wearing headphones. Hello again. This is Ben Hitchcock Cross talking to you today at long last. Geez, I can't imagine that there is a point in my life now where if I do not contribute for some 10, 15 days, it's kind of shocking. But I needed it. I appreciate the patience and forbearance. And yeah, I won't say that I'm back or not, but I will say that I have been in a battle since Christmas that has frankly exhausted me. And I'm always real reluctant to say that to give people the, thought that they could tire me out here. But let's put it like this. I think this is sort of the final straw in all of that. I had to focus my attention most mornings on clarifying the law and the facts for this particular ALJ Gelhard. Where we were last at, and I just want to be clear for some housekeeping here, we have not finished with Alice DeLau's Novak decision, and we kind of moved on to this ALJ Gelhard debacle, for lack of a better word. We had the lead up to the decision, and then I recorded the decision with a bunch of YouTube playing in the background, which, although it was an hour and 20 minutes, it just was not salvageable, and that's how that went. So then this, and I think where we were at there was the judge had told everybody that I was Jewish, or put it another way, the judge had said that I had told everybody that I was Jewish, which, I still maintain is a bit of a stretch from my comments, which in actual fact were just, hey, you seem to know about your boss's, Secretary Petchacek's and Secretary Carr's holiday plans, and you admit that. And what about other people who might have had other holiday plans, or, for example, Hanukkah that happened all last week, which you didn't seem to care anything about. So my point is that the judge inferred that because I was sticking up for Hanukkah, say, that therefore I was Jewish. That's troubling for a lot of different reasons. But I think it's even beyond it's unprofessional. I mean, he put it in writing that Ben Hitchcock Cross states that he's Jewish. Okay. And we're going to get on to some other things on this. And we've got the log here. And he put that in the state log. So I kind of pushed on him back saying, you just cannot have that in there. And again, whether I'm Jewish or Episcopalian or celebrate Kwanzaa, I don't know that that's the state of Wisconsin's business. I don't know that it's relevant to that case. But again, the thing that I want to get the most clarity on is this is from an ALJ whose job it is to decide whether or not employers are violating religious employment protections. And he's tasked and has been there, I think, since 1998 with the task of identifying religious discrimination in workplaces. We also note that we have from his training logs here, I believe he got a 75% based on the public record there on the training they all had on creating a discrimination-free workplace. So some people think that a C is good enough, passing is good enough, but others think maybe that these sort of equity, diversion, and inclusion workshops testing things are all a big scam. And there's probably other views on those as well. But it's not a data point that you would want if you were such a judge, and especially combined with these statements there about a employee's attorney's religion. So I think that kind of set the tone there and set everything else off. We've got some bigger issues going there. Remember, this judge, if you don't recall, invited me to withdraw the employee's case if I believed that the judge had a conflict of interest. Just the whole statement on that is really improper. I don't do anything. I don't withdraw anything. I am a representative of employees, and my job is to use the law and my expertise to represent them. Meaning, I'm not them. I'm speaking on their behalf. It's an important concept to understand. Also want to know that this judge tried to dismiss the whole case out, but then in August, was told by LIRC, the Labor and Industrial Review Commission, that he couldn't do that. And before he just threw somebody's case totally out, he had to find out what actually the employee had done to take care of things. Okay? So he proposed to have the employee to send an email directly to the employee and have the employee respond to him directly back, even though he knew that LIRC, the requirement for them was to hold a hearing. Okay? So, of course, he didn't tell us all that, but we had to go read the actual thing that he cited, and then we found that out. We also found a statement in there from LIRC saying that this judge was entirely too focused on the actions of the employee's attorney. And that's why I bring that up again here, because it seemed very much to me to be like what was going on here. There's a lot more to get on there. I think I've got a 10-point erroneous exercise checklist going on here, meaning I think 10 things that the judge did either in fact or law that's not only just wrong, but I highly suspect that he knew was wrong in the first place. Now, just on that subject here, I know this is sort of a freewheeling diatribe here, but thanks for sticking with me. On that subject there, let's say you have a situation where a judge makes a decision, and then the decision is the basis for which he makes the decision, and the law for which he makes the decision is completely wrong. Okay? And then the judge comes back and changes the law and the reasonings, maybe slightly, maybe a lot, maybe not at all, who knows, but then comes to the same conclusion. There's a serious problem there, and I'm going to explain to you why. Judges, to be worthy of the name judge, and I don't care if you're an attorney working for the governor of the state of Wisconsin or you are a district court judge authorized by the United States Constitution or something in between. A judge, their main duty is to sift and winnow through the evidence presented by each side to come to a decision, whatever their decision is. If it's about discovery, there needs to be sifting and winnowing. It's about the ultimate facts of the case, same process. Sifting and winnowing, I really didn't understand that there. But let's say you want to keep your seeds. There's the chaff, the stuff you don't want, and then there's the stuff you do want, the seeds. Like, I don't know if you've ever seen milkweed, for example. All the good stuff's at the bottom. Everything else is chaff. So there's a technique. Otherwise, you're going to have a lot of fluff in your face and no seeds. So that's what a judge is supposed to do, is to get down to the seeds. Okay? Sifting and winnowing. But more than that, a judge has to give evidence that they've done something. That doesn't have to be a lot. That's why they sometimes say statements for the reasons on the record, or for the reasons, stated orally before. I'm granting this motion, or I'm rejecting it. Okay? Well, then you can at least look back on the reasons in the record. Okay? So two things have to happen for due process to be satisfied. Okay? A judge has to both sift and winnow, make a decision based on the evidence. Okay? Not something else that they secretly know, not some information that they want, they have in their back pocket, not somebody that they talk to at a bar or, in the workplace. Not anything else but the competent admitted evidence of the both parties. Okay, so they've got to make a decision. That's why we came to the judge. But again, you don't expect a judge to have two parties go to them and then they go to somebody, the King of France, and the King of France tells them, nah, it's all garbage. Here's what you need to know, whoever it is. Okay, that's what you don't want. So to protect that, the judge has to both make a rational decision-making process. They have to give evidence that they're doing it. Okay, that's more than anything else is the reason for written decisions. And same thing with oral decisions, why the judge explains what the rules are, what the facts are, and how they've applied these facts to the rules to come to their outcome. I mean, that's what legal reasoning is all about. So if a judge doesn't put anything in the record, or if they shift everything around but then come to the same conclusion, it really raises an issue in your mind of, is there sifting and winnowing going on? Or is there prejudice? Has this matter been pre-decided, prejudged? So that really, when we're talking about what are the concerns here with with these kind of decisions, and why is this, bothering me, and why don't I have more time for you guys? I would say that it is really fundamentally disturbing when, the Jewish stuff aside, that I think is not professional. I don't think it's warranted. I think it's highly disturbing. I think it's kind of possible for somebody to continue to be a judge having said those things. Now, he didn't say all Jews are jerks, right, or anything along those lines. It wasn't, quote, anti-Semitic in nature. It was irrelevant, unprofessional, not very well sounded in reason, I think, but not necessarily disqualifying. Okay, that's at least where I'm at right now. I do think, though, to have a situation where you're wrong on the facts and the law in a decision, and that's pointed out to you, you accept that. And I just want to be clear here. It's not only to be wrong, it's to have been discovered to have been wrong in a way that's not only provable, but it seems to be provable to say that you knew or should have known that this was not the case. And by the way, what happens if we're just going to stick with attorney, not a judge, but let's say an attorney knows that they have submitted to you just a portion of the law, right? Let's say there's a law as a whole sentence with a couple of parts to it. Let's say there's 3 parts to it, okay? And let's say the judge only tells you about the middle part. But the first part and the third part totally contradict the point that the judge is trying to make. That's really significant. And I keep saying judge, but let's say I'm doing this as an attorney. I would expect to be called out on it and probably have some professional consequences. I don't think I might not lose my license, but I would expect to be embarrassed in front of my clients at the very minimum. You don't get very many chances like that when you're an attorney. But what you never do, and they tell you this in law school from day one, is you're never dishonest with the court or the other side about the facts or the law. And it's the dishonesty here. You don't have to tell everybody. You don't have to say, hey, here's this law that says I'm an idiot. Hey, here's this other fact that says I'm, wrong. But you can't go and say something that we'll stick with the law. You can't say that the law is X when you know it's also Y. You have to tell the judge that it's X and Y. You have to. And not only is the big thing here is everybody assumes lawyers are sharks and you've got every way to fight, every dirty-handed trick. It's an adversarial process, that's for sure. But it is completely out of bounds to misquote the law. And especially if you misquote a law in a way that completely undermines your position, meaning the fragment that you cite is actually not what the law is. And it's really clear, because when you cite just a fragment, it's kind of assumed that you've read the whole sentence. When if you haven't read the whole sentence, you should have. And you knew you should have. So that's why that's a problem. I mean, and it's even more problem when you have, and this is the situation, that instead of having a full judge with, the judicial commission above them, you've got an attorney who, if they've done something like this, you can imagine how that would make it very difficult for people to think that judge/attorney was really capable of judging. And if you had a bureaucratic institution that took no action against that judge/attorney, and a governor who took no action against that judge/attorney, who they knew was doing that, that would significantly undermine that governmental institution and the administrative law that governmental institution is designed to uphold. And I think that more than anything else on the institutional end here of what we're getting to is what needs to be addressed, and why I think it has been so problematic here and difficult to respond. I mean, the amount of work that it takes to explain to somebody that you cannot only cite the middle of the sentence when the first part of the sentence and the last part of the sentence directly contradict your position. And I tell you that the employees of the state of Wisconsin should not have to do that to move forward. They should not have to explain to lawyers who are calling themselves judges that they cannot misquote what the law is. They shouldn't have to. So I think that is a significant issue that we've raised here today. And I think it's a significant problem. And we've had this in other situations, and we've displayed this on this channel, but I think never have we had a situation like this where the middle of a sentence is quoted and the beginning and the end completely contradict the position. So we also had a situation like this where there's a fact that this judge found. That's one of their jobs. They find facts. Guess what? The fact didn't happen. Never happened. The attorney knew it didn't happen, didn't say anything. And what it was that the attorney had, this wasn't even in the motion. This was in another motion that the attorney had said X, Y, and Z. So the judge, and guess what? The transcript showed that never happened. We'll get into it, but hey. So what's going on? It's truly incredible here. If you're an attorney and you misstate a fact, or let's say you put something that's wrong, you have a duty to correct it immediately. When somebody brings it to your attention, you have an independent duty to correct that fact, whether you're an attorney/judge or just an attorney. Got to do it. So, for example, if you find a fact as an attorney/judge that never happened, and that is brought to your attention, it's not the thing to do to say, well, it doesn't really matter if I found that X happened or Y happened. Either it could be X or it could be Y. What the heck? You see how then there's no sifting and winnowing. There can't be any. And you are completely rejecting that whole concept that it's your job to sift and winnow. If a fact is pointed out to you as being incorrect in a decision that you rely on, right? You find these facts and you say, I'm making this decision because of these facts. Then that fact is pointed out to you to be incorrect. It's not acceptable to go say, well, there's this other fact here that I didn't find that then supports my position, so I'm going to do it anyway. You could see how that same situation, The attorney/judge has the duty to correct the fact, period, the end. Just like he had the duty to correct the law, period, the end. But then, if your misstatement of law is essential to something that you're doing, a decision, for example, and the fact is essential, and we know it's essential because it's in there, and you're using that fact to come to the decision, and then you say, it doesn't matter that the fact that I relied on is wrong or the law that I relied on is wrong. I'm coming to the same conclusion no matter what. In my mind, that is what is called prejudice, that you have prejudged the outcome, and the decision is a mere formality to get to that outcome. So that's my analysis there on where we're at. Thank you so much for sticking with me. I am going to do a brief video after this on where we're at on the deposition, so hopefully explain that. But hey, stick with us. We'll keep you informed.